A3. Thank you, Mr. Ziegler.
So good morning, Your Honor. Again, my name is Barton Thompson. I'm representing the California Resources Corporation in case number 17 CV 000790. So let me start out first by noting that after the court adjourned yesterday, counsel for all the sides conferred on how we could try to resolve these proceedings by the end of tomorrow. And we think we have found a process that should work. We will start today, as was originally planned, on facial takings. We will then, this afternoon, begin the single subjects issue. And our hope is that we might even be able to finish that today. We're not totally confident in that, however, so to the degree there's any left of the single subject issue, then that will go over into tomorrow morning. And then also tomorrow we will deal with the substantive process issue, followed by the general plan. And again, our hope is that we will have phase one wrapped up by the end of tomorrow.
Great. I do appreciate council working with
you. Okay. So if your honor is ready then to move on to a new subject. At this point, we will turn from consideration of the purposes of Measure Z and the question of whether or not Measure Z has been preempted by state and federal regulations. And we will turn instead to the question of the impact of Measure Z. In particular, the economic harm and injury of economic Z to the plaintiffs in this particular case, and that obviously brings up the question of facial takings. My guess is I will probably go until the morning break, and then following me, I believe that two of the other plaintiffs will want to do presentations. I have a full set of presentation slides. But I really encourage you to interrupt me at any particular point with any type of questions that you have, because the most important thing is to answer the questions that you have. So going to the very first slide, I'm going to both begin and end my presentation today with quotations from Justice Oliver Wendell Holmes in the seminal case of Pennsylvania Coal versus Mayan. If there is any legal document that has actually shown its ability to hold up over time, better than the 1976 Attorney General opinion, it's Justice Holmes' opinion in the Pennsylvania Coal case, which I think remains today probably the most quoted opinion from the United States Supreme Court in the taking lexicon. And when Justice Holmes announced that, in fact, regulations could constitute takings, he set forth this basic general rule, and that is that while property may be regulated to a certain extent, if that regulation goes too far, it will be recognized as a taking. The Supreme Court, for the last century, has spent a lot of time trying to figure out what too far means, but I think that it's fairly clear that Measure Z is unprecedented in how far it goes in regulating the plaintiff's property. And I think it's unprecedented in two ways. The first is that as I will go into, in the case of the California Resources Corporation, Measure Z destroys all of the economic value of our property, which again, as I'll explain, constitutes a lucas taking. I've been teaching property and regulatory takings since before lucas was decided, and in that entire period of time, I think I've probably seen no more than two handfuls of lucas takings. And that's because in most situations, governments try to balance the interest in regulating property on one hand and the property owner's interest in using their property on the other. So it's actually quite uncommon to have a situation where you have a regulation that destroys all the economic use of a piece of property. But Measure Z is also unprecedented in the second one, is not only does Measure Z destroy all the economically viable use of California Resources Corporation's property, but in addition to that, it adds Section 6C to its provisions. And I have looked, I have not been able to find anything similar to Section 6C that tries to take the initial determination of whether or not a governmental ordinance is a taking and hand it over to the administrative agency responsible for actually implementing the provision. And furthermore, then tells that particular agency that if they find a taking, then they have to permit, or they can.
It says that they may.
They may.
It does not say that they must.
That's absolutely correct, Your Honor, and that's in fact one of the interesting aspects of this, that they may provide an exemption, but only to the minimum degree necessary to avoid that takings context. So if we go to the next slide, this simply sets out the various issues that I will be talking about. So I'm going to just very quickly give you a little bit of background on the California Resources Corporation. We will then show that Measure Z affects facial taking of CRC's property, and I should emphasize that I will simply be talking about the California Resources Corporation's property, and other claims to talk about their factual cases. Then I will discuss why this case is ripe for review. I will go on to talk about why Section 6C is invalid, and finally I'll come back and talk about the appropriate remedy in this particular case. So again, I'll start out with the California Resources Corporation. So if we go to the next slide, just a little bit about California Resources Corporation, which I frequently abbreviate as CRC. We are the fourth largest oil and gas producer in the state of California. We are both new and old. We have existed only since 2014, but we basically were a spinoff of Austin Petroleum. So all of Austin Petroleum's California properties were spun off and created CRC. Even though we are the fourth largest oil and gas producer in the state of California, we have no producing wells in Monterey County. Although we have no producing wells, we do have a large number of both mineral fee estates and mineral leaseholds. So we have mineral fee estates in approximately 12,000 acres in Monterey County, and we have mineral leaseholds in approximately 21,000 acres in Monterey County. And these properties are exceptionally valuable. And one indication of that is the fact that over the last 3 years, we've paid approximately $1.5 million in property taxes to Monterey County on those particular properties. And CRC has invested money in both exploring and in sort of the initial stages of thinking about how to develop those particular properties. However, given Measure Z, and its ban on new wells, and also its ban on activities involving injection under Measure Z, those particular properties that I'll come back to in a moment are valueless. So going on to the next slide, the first thing I want to do is just very quickly provide a takings law overview, which is probably material that is already familiar to Your Honor, but I think it's useful just to set it out. So going to the first slide, takings, as you know, fall into two basic categories. The first are physical takings. Those are the takings we are most familiar with. And physical takings are both the traditional exercise of eminent domain, where, for example, the government wants a piece of property to build a new post office on, or physical occupations of a piece of property. The best example there is where the government builds a dam, backs up the water, and floods somebody's property. So even though they have not exercised eminent domain, they have physically occupied that property. Moving to the regulatory side, and again, the standard here is that a regulation is a taking if it goes too far. The Supreme Court, and if we go to the next element here, have created two per se categories of takings, trying to avoid the problem that regulatory takings under that general 2-PAR standard can be very complicated to apply and very fact-intensive. Supreme Court has said there are 2 settings where it's fairly easy to see whether or not there is a regulatory taking. The first, which is exemplified by the Supreme Court's decision in the Ardo case, is where you have a regulation that leads to a permanent physical occupation of someone's property. Occasionally you will find the Supreme Court merging that category with the physical occupation category under physical taking. Sometimes you see them separate them. Neither of them are directly relevant in this particular case. The more important one for our purposes is that second per se category, which is where you have a regulation that leads to the destruction of all of the economically viable use of a piece of property. And that's the Lucas case that we will be going into in more detail. If a regulation, however, does not fall into either of those per se categories, then plaintiffs turn to the concentric case, and the property owner has to show that the regulation has such a severe impact on the property owner. But balancing a variety of factors, and I'll come back and talk about this in a little bit more detail when we talk about Section 6C, but balancing a variety of factors, the court can still conclude that, in fact, the regulation constitutes a taking of someone's property. For purposes of our facial takings challenge, though, again, the key category here is that second per se category of regulations that cause the total economic loss of a piece of property. And if we go on to the next slide, the Supreme Court in the Lucas case explained why it is that when a regulation destroys all the economically viable use of a piece of property, it actually is a per se taking. As the Supreme Court said, to the degree that if you deprive a property of all of the economically viable use of a piece of property, that's, from the landowner's perspective, the equivalent of a fiscal appropriation. Because, as the Supreme Court said, the profits that you make on a piece of land is the land itself. And therefore, again, you've destroyed all the economically viable use. That, to the property owner, is the equivalent of a fiscal appropriation. The Supreme Court, in addition to this point, made 2 additional points as to why destroying all the economically viable use of someone's property entitles them to compensation. One of the other points the Supreme Court makes is that in a typical regulatory case, say for example a zoning case, although a property owner might lose a little bit of value because their property is zoned, they probably gain some value because the government is simultaneously regulating the neighbor's property. And over time you would expect that that might wash out. The term that the Supreme Court has frequently used there is reciprocity of advantage. That sometimes you lose, sometimes you win, but in general everything balances out. If, on the other hand, you have all of the economically viable use of your property destroyed, then under those circumstances there's no opportunity for that type of reciprocity of advantage because your property has been entirely wiped out. And then the third point the Supreme Court makes is that, going back again to Justice Holmes' point, the regulation is a taking if it goes too far. It's impossible to go any farther than destroying all the economically viable use of somebody's property. So going to the next slide, the other thing that the Lucas case does in this case is that it helps to illustrate the difference between a facial taking and an as-applied taking, an issue that we discussed briefly in one of the first pre-trial conferences. So as this slide shows, a facial taking is a situation where the regulation's mere impact constitutes a taking, where you can look at the terms of the regulation and evaluating the language of the regulation, see that a taking has occurred. On the other hand, the typical as-applied taking situation is, for example, in a zoning ordinance, where there are general standards set out. And until those general standards are applied to a particular piece of property, we don't know how that zoning ordinance is actually going to impact that particular property. We have to wait until there has been an individualized governmental decision on that particular piece of property before we can evaluate whether or not there is a taking. And as I will come back to in a second, Lucas makes it quite clear that Lucas itself was a facial taking, and that Lucas frequently can constitute a facial taking. So what I want to do next is just talk very briefly then about the facts of the Lucas case. So if we go to the next slide, this is actually a picture of the Isle of Palms off the coast of Charleston, South Carolina. This is the setting of the Lucas case. This particular subdivision is what was known as the Wild Dunes Resort. And David Lucas had purchased 2 pieces of property with the thought that he would develop them as home sites. And those 2 pieces of property are actually quite obvious in this particular photograph. They are the 2 vacant lots around which you see homes having been built. David Lucas expected that he would actually develop, again, his 2 lots. That's why he purchased them. But before he developed the properties, South Carolina passed a beachfront management act, which prohibited those lots from being developed. The picture to the right is actually David Lucas standing on one of his lots. And the evidence that was presented to the South Carolina trial court was, first of all, evidence that David Lucas had purchased these lots for a home site. He owned those lots. And second of all, evidence that the Beachfront Management Act had wiped out the value of those 2 pieces of property. The trial court, after receiving that evidence, going on to the next slide, made a variety of findings. First of all, that Lucas had bought 2 lots that had been zoned for homes. Second of all, that the act decreed a permanent ban on construction. Third of all, that prohibition deprived Lucas of any reasonable economic use of the lots. And I should mention here that when you get to the Supreme Court's opinion, they use different adjectives. Sometimes they say deprived Lucas of all economically available use, sometimes all economically reasonable use, but the concept is basically the same. And then finally, going to the last point, he therefore found that the property had been taken by the operation of the act itself, not by any later application of the act, but by the face of the act itself. That works its way up ultimately to the United States Supreme Court, and going to the next slide, the U.S. Supreme Court found that this was a facial taking, and in footnote 6 in its opinion, they expressly noted, as you can see here, that the cases say repeatedly and unmistakably that the test to be applied in considering a facial takings challenge is straightforward. A statute that regulates the uses that can be made of property affects the taking if it denies an owner economically viable use of his land. And going to the next slide, the court also emphasized that although you obviously have a facial taking and you're looking at what the act does, that doesn't mean that the property owner doesn't have an evidentiary obligation. And in particular, the property owner in this particular case, David Lucas, had to show that the Beachfront Management Act denied an economically beneficial use of his land. So taking these various points and going to the next slide, this means that there's basically 3 steps of a Lucas facial claim. The first step is that the property owner has an obligation in court to show that they have valuable property that can be used for a particular purpose. Second of all, the property owner has to show that the law that they are facially challenging restricts that particular activity, restricts the use that that person is going to be making of the property. And that finally third of that restriction destroys the economic use, all the economically viable use, all the reasonable economic use of that particular property. So that's the summary of Lucas. Going to the next slide, what I now want to do is, for purposes of the California Resources Corporation, set out what we have shown and how this is consistent with the three requirements of Lucas. So going to the first slide, I want to start out by mentioning that there is one difference between this case and Lucas, and that is in Lucas we were dealing with a fee simple absolute, whereas in this particular case we are dealing with a minimal right. In most cases dealing with takings, in most property cases generally, we are dealing with a fee simple absolute. But the law has long permitted fee simple absolutes to be divided into two different types of estates. The first type of estate is a surface estate, and that surface estate permits the owner of the surface estate to use the surface for whatever purposes they want. But in the case of CRC, we're dealing with two different types of estate. The one that we see listed here, number 2, the mineral estate. That permits us to produce oil and gas from underneath the surface. And the only use that we are permitted for the surface is to put our equipment, our well that is necessary to actually pump that oil and gas out. So we can't put a home there, we can't put a trailer park in, can't put a doghouse in. All we can do is to put our oil well. And then the other type of estate, which is relevant to CRC's claim, is an oil and gas lease. And again, exactly the same as a mineral estate. We are permitted to remove the oil and gas from beneath the property. We can put an oil well on top, but we cannot make any other surface use of that land other than what's necessary to get the oil and gas out of the property. Mineral estates and oil and gas leases differ in terms of their economic terms, but in terms of the rights, they are effectively the same. They are subsurface rights with that one very limited form of surface right. And going back again to the next slide, to Justice Oliver Holmes and the Pennsylvania coal case. One of the key and important holdings of this case is that that mineral right is a constitutionally protected right. Not only is it a constitutionally protected right, but as Justice Holmes noted, to make it commercially impracticable to mine that coal. That case that was dealing with coal rather than oil and gas, it was a coal right, has very nearly the same effect for constitutional purposes as appropriating or destroying it, which again, the Lucas Court comes back to. So now I'll turn to the, just sort of a quick schematic demonstration of the similarity of Lucas on the one hand and CRC's claim on the other. So again, Lucas, and you can see this is sort of a schematic that's similar to the photograph I showed you earlier. Lucas owns those two vacant lots there. And what Lucas wants to do is to build houses on both of those two lots. So next. Okay? That's what Lucas would like to do. But number 2, there's a ban under the South Carolina Coastal Management Act, a ban on new buildings on the lots. So although Lucas would have liked to have built those two homes next, he's not permitted to, which leads to the third and most important finding of Lucas. Lucas destroyed all the economically viable use of the property. Now, if we go to the next slide, we can compare this to Measure Z. Measure Z, there are a variety of oil and gas producers who already have wells in this particular area. What CRC has, though, is a variety of mineral leases and mineral estates that were purchased to do the same thing. We want to be able to develop that oil and gas, so we own that mineral rights. We want to put wells on it, but number 2, the Measure Z bans all new wells. And as a result, we're not going to be able to put those oil wells there, and that leads to the third fact, which is that Measure Z destroys all the economically viable use of the properties. So you can see that even though we're dealing with a different type of estate, that the similarity between Lucas on the one hand and Measure Z on the other is exceptionally similar. Going then to the particular facts, because ultimately, of course, that's what the report will be focused on. On the element one, that we own constitutionally protected property. Our declarations, as well as the county records, show that we own and lease, as I mentioned earlier, something in the nature of 33,000 acres of oil and gas property in the county of Monterey. And second of all, these properties have value. We think that's self-evident in the fact that the county actually assesses us property taxes on those mineral estates. But you will also find in the various declarations of both CRC employees as well as our expert petroleum appraiser that all of those properties have value and that they were purchased or acquired because of their value. We are an oil and gas company. That is the reason why we acquired these interests. So then moving, and I should emphasize there's no contrary evidence in the record. There's nothing to suggest that we do not own valuable and therefore constitutionally protected property. Next slide shows that under element 2, that Measure Z categorically prohibits new wells. There are two provisions that we are focused on. One is section 1.23 that prohibits the drilling of new oil and gas wells, something that we've gone into in detail over the last 2 days. And then also section 1.22, which bans activities in support of both oil and gas wastewater injection and wastewater impoundment. And our declarations, expert declaration, show that in order to produce oil and gas from any of our properties, we have to be able to drill production wells, we have to be able to drill steam injection wells, and also engage in wastewater injection. Going to the next slide, I couldn't resist putting this in here because this to me was one of the most relevant things from the last 2 days, is that we were told by counsel for the county that the language of Measure Z says no new wells. And that although there's an argument that the county has made as to whether or not that means you can have no new net wells rather than gross wells, that it's quite clear that it's Measure Z is designed to not permit the expansion of oil and gas production. As council noted, you can look at the findings, and those findings all make it very clear that if you're in the situation of CRC, we are not permitted under Measure Z to operate new wells. Going to the next slide, that then brings us to the third Lucas element. We have to show that that destroys all the economically viable use of our property. As the McMahon declaration that we have submitted indicates, the vast majority of our property has no infrastructure whatsoever. So we would have to start from scratch and drill wells if we are to produce from those wells. There is no property with operative infrastructure. There are some pieces of property that have some old equipment on it. And in the case of one parcel, there is a well that apparently can be operated. But on that particular parcel, the wastewater injection well that is there right now cannot be used because of the pressure level in that particular field. So even if we could, again, that's just one parcel. If on that one parcel we were able to use the production well, we would still need a new injection well. And that all means, as this third bullet points out, that we can't extract oil because, again, as our Miller declaration, as who is our expert witness, as well as the expert witness for the other side has emphasized, you cannot extract oil without new wells. Going to the next slide, the two experts agree on this particular point. So the expert at the top is the county expert, and in his deposition said, if there are not any existing wells there, yes, you'll need to drill. And our expert witness, Mr. Miller, who I think was somewhat fierce in that particular picture, I think he needs a new one, has stated that the development of the CRC mineralized position will necessarily require the drilling of production and injection wells. That might be obvious, but again, we want to make sure all of that is in the record, Your Honor, in support of our case. Finally, going on to the next slide, again, our expert witness, Mr. Miller, who is a certified petroleum appraiser, as he noted, absent the ability to conduct drilling and development, the value of our leasehold and mineral fee estates are eliminated. Going on to then the next slide, in the opposition briefs by both the county and interveners, there's no evidence to the contrary on any of these points contained. There was, however, some speculation in the county's brief, and the county in particular said that we, I think we, and the royal we, do not know some things. And what I want to show is that we actually do know. First is, they said we don't know whether or not CRC's mineral rights are valuable. Well, actually, taxes, our expert appraiser and our witnesses all established that those properties are valuable. County also speculates, well, we don't really know whether Measure Z prevents the production of the mineral rights from CRC's properties. And again, the text of the statute and all the experts and our CRC witnesses agree on that. Third, maybe we don't know whether other uses might be made of those rights. But we've shown that under mineral estates, there are no surface interests. And therefore, both our expert and our witnesses say that there is no other use that can be made here. And then finally, the county speculates, we don't know what the economic impact is. But again, Your Honor, our expert witnesses as well as our witnesses have all said that the economic impact is to destroy all of the economically viable use of these properties. So going to the next slide, this just compares Lucas on the left-hand side with CRC's case on the right-hand side. We own mineral interests, a valuable mineral interest. We cannot drill new wells, therefore we cannot produce, and that means that our mineral rights have no use. So going on then to the next slide, this is not directly legally relevant, but in comparing Lucas with our case, I thought it was interesting that actually we're even a little bit more egregious than Lucas. Lucas actually could make some use of his land. If you look at the footnotes in the Lucas case, turns out Lucas could have put a boardwalk on his property. He could have put a trailer on his property. Lucas could have done something that's sort of similar to this particular picture here, brought his friends over for a party. We can't even do that, right? We cannot put a trailer on our property, except in the production of oil and gas. And similarly, Lucas conceded that the South Carolina Act had a valid police power purpose, whereas, as you know, in this particular case, the plaintiffs dispute whether or not Measure Z is valid, even beyond the takings issue. Again, this is not directly relevant to the takings question, but again, just to show that the case here, if anything, is more egregious than Lucas. And so finally, next slide, we believe that we've proven each element of the Lucas taking. And next, the county and intervener, we do not believe they've got anything to rebut that, and instead their focus, and what I will turn to now, is the argument that we need to exhaust administrative processes. And so this brings us to Section 6. And so the next slide sets out what would be the normal procedure in a case involving a facial taking like CRC is presented here. Court would issue declaratory relief to CRC, and at that point, county would choose whether to exempt CRC or compensate CRC, and then finally, if for any period of enforcement, CRC would receive compensation.
Well,
Yes, Your Honor.
okay, normally,
Yes.
absent section 6C, which we'll deal with later, the county chooses whether to exempt or compensate. How procedurally does that work? If you're saying in the absence of some statutory or regulatory provision for determining whether CRC can be exempted or compensated. How does that, who does that?
Okay. So
Especially when the ordinance says it can't be modified or changed without vote of the voters of Monterey County.
that's an excellent question, Your Honor. So the important thing to recognize about the takings clause is that the takings clause does not say that the government cannot take any particular regulatory action. All it states is that the government cannot take a regulatory action without paying compensation. So in deciding that, declaring that Measure Z constitutes a facial taking, what the court is saying to the county, and the initiative is effectively a county ordinance. The county in that particular setting, once it's determined that it is a taking, has two choices. The first choice is to go ahead and provide compensation. And so the county could determine, yes, we actually want to bar CRC from developing any of these mineral interests. We will pay compensation. The other possibility, though, is that the county says, no, we do not want to pay compensation. If the county does not want to pay compensation, then under the Constitution, the county cannot enforce Measure Z against CRC. So it's actually a constitutional prohibition on the enforcement of Measure Z against CRC if compensation is not paid.
And as that work here, the governing political body of the county, the Board of Supervisors, would have to decide whether it was going to decline to enforce this against CRC, or whether it was going to pay compensation for the 33,000 acres, whatever it is, lease and fee on mineral rights at CRC.
That's correct.
Do the cases discuss how long this procedure would take, or whether there are limits on how long this procedure would take to make the determination?
So the California cases that deal with this set out the basic procedure, but they do not specify that the county has a specific number of days to make that decision. Two important elements of this, though. First of all, under the First English case, to the degree that the county has any delay in making a decision, then the county is liable for temporary taking damages during that period of time. So that means that the property owner does have compensation protection during that period of time. Second of all, although I'm not aware of a case in which a county has taken half a year or a year or was delayed in making that particular determination, at some point I think a court would conclude that the continued enforcement of that provision without the payment of any compensation is itself unconstitutional.
Are there any guidelines as to what the court does in the interim? Does the court enjoin enforcement until a decision has been made? Does any case talk about that?
And we can gain or we can get citations for Your Honor on this particular issue. But part of the problem in these cases is that during these periods of time, the plaintiffs are not able to actually exercise their constitutional rights. They have not yet received compensation, and so I think it would be permissible for a court to enjoin it during that period of time.
To avoid the temporary takings.
To avoid the temporary...
In compensation.
Absolutely. To avoid the temporary takings and the compensation issue. The other thing that the courts have frequently emphasized is that although plaintiffs are entitled to fair compensation, that even fair compensation is not the same as actually exercising the property right itself. So I think there would be a good basis for an injunction both to avoid the problem of temporary takings and to, again, protect the plaintiff's property rights during that period of time.
But if you carry that to its logical conclusion, wouldn't that mean that the court could enjoin any application of the ordinance even if the county decided to pay fair compensation? By saying that fair compensation is not the equivalent. If I understood what you're saying, you're saying that fair compensation is not the equivalent of the use of the property. Therefore, that provides a basis for temporarily enjoining enforcement of the ordinance until the decision is made. Isn't that same reason to hold true after the decision is made? Fair compensation is not the equivalent of having the use of the property, and therefore monetary compensation would be impermissible. So, Your Honor, in the case, what the Supreme Court has ultimately concluded is that although it is impossible to fully compensate property owners, that just compensation requires simply the payment of fair compensation. So certainly once that has been paid, then at that point the property owner has been fully compensated under the constitutional provision. The problem is simply the one that you noted, where you have a situation where the county hasn't actually determined whether it wants to go that particular route. I was trying to explain why it might be in those cases that an injunction would be permissible. Of course, we could also, in particular situations, ask for a writ of mandate. Which takes that. Yeah. So, going on then to the next slide. So, talk about the way it would normally work in these particular cases. And as you pointed out already, we also have Section 6 in this particular case. And there's two portions of Section 6 that the parties have talked about. The first section is Section 6B, and interveners in particular focus a great deal on Section 6B. I want to say two things about Section 6B, which basically provides, as many statutes do, that nothing in the statute is meant to violate the Constitution or laws of the United States and the state of California. The first is that if the only thing that was in the statute was Section 6B,
we would not be troubled. Presumably, if this was the case, this simply reaffirms that the statute cannot be utilized in an unconstitutional fashion. The problem is with Section 6C, which, as the interveners have said in their briefs, actually, in the case of takings, is meant to implement Section 60. If we go to the next slide, because my eyesight is getting bad, I thought I would blow up Section 60. And as you'll see here, and as you've already mentioned, this permits the Board of Supervisors to grant an exemption if they find two things. First of all, that the application of a provision of the initiative would constitute an unconstitutional taking. And that second of all, the exception. And as the county has interpreted Section 6C, this is an exception that the property owner has an obligation to ask for and define. If what the property owner asks for an exception will allow additional or continued land uses only to the maximum extent necessary, minimum extent necessary to avoid such a taking. So go to the next slide.
Which presumably, which the language of this statute commits to the Board of Supervisors to decide to what extent it would be an unconstitutional taking.
That's correct.
Isn't that a judicial function?
That is very much a judicial function, and furthermore, as you may well have had experience in, determining what is an unconstitutional taking, when you're not dealing with Lucas, but you're dealing with Penn Central, is not the easiest legal determination to make. And so in this particular case, what that language would do would be to take not only what is the basis and the province of the judiciary to decide, and then give that to the board and force the board not only to apply Penn Central, which is a very difficult case to apply, but to furthermore figure out under Penn Central what is the least imaginable use that you can permit. So it's a question that I've never seen a court have to confront before, let alone a Board of Supervisors, a political body with no experience in these types of determinations. So going to the next slide, it's important, and this really focuses on what you just emphasized, Your Honor, that Section 6C takes takings claims out of course, which is where they belong, and assigns them to the board instead. So effectively what Section 6C is a forum selection mandate. It's saying we do not want to go to the courts. Instead, we would prefer to go initially to the Board of Supervisors. Second of all, and this is an important element of this, even to qualify for an exemption, it makes a taking a necessary condition. So this is not something that takes place before a taking. This is something that takes place after the taking. And then third of all, because of that focus on the minimum permitted under a Penn Central test, as I'll come back to and emphasize again later, it embodies what we believe is more hostility toward property rights. So going to the next slide, we think it's useful. Again, this gets to what Measure Z Section 6 does and doesn't do, to compare the Measure Z Section 6 process with a typical permitting process, because virtually all of the cases, in fact I'll say all of the cases, to which the county and the interveners turn in arguing that this case is not right for consideration, we should exhaust administrative remedies, fall in that first category of your typical land use permitting process. So we're just going to have a schematic here. So under your typical permitting process, if you want to develop your land, you start out and you submit a permit application for, say, developing a piece of land. Then going to the next box, that's then reviewed by an expert planning department. That planning department We'll look to see whether or not you've tried to put too many lots into your subdivision. Maybe you don't have sufficient open space. Maybe you need greater amenities. Maybe you need farther setbacks. But they will look at those sort of policy decisions from an expert perspective. And then that planning department will do one of several things. It will approve your permit, in which case you can move forward with your construction. It will approve it with conditions, and it might be that those conditions are fine, in which case, again, you'll proceed with your project. It might be that they will deny your permit, or they will condition the permit on a condition which you believe overburdens your right to develop the property. And in both of those two cases, if a taking occurs, that's where the taking will occur. And that's where you would then go into the court with an as-applied challenge. Compare that to Measure Z on the right-hand side. With Measure Z, the taking occurs at the very outset. The taking has occurred, will occur, as soon as the temporary stay in this particular case is lifted. Measure Z goes into effect. We're no longer able to develop our properties. And if a taking occurs, then rather than go into the court, what Section 6 tries to do is to instead force the plaintiffs to go to the Board of Supervisors with an application for an exemption. That's then actually heard first under the current draft ordinances. It would be heard first by a hearing officer, but ultimately under the statute, it has to be heard before the Board of Supervisors, a political body with more experience in this particular area. And then the Board of Supervisors, again, has several choices. So it can grant the exemption if it finds a taking. And if it grants that exemption, given that the taking has already occurred, there would be temporary taking damages, or it could deny the exemption, in which case at that point we would be back in court again, arguing that there has been a permanent taking. So it all comes back ultimately to this court, where we think that the case should be resolved today. But the important thing is to recognize that your typical land use permit process, permitting all takes place before the taking. In this particular case, the taking occurs prior to the application. And in case there's any doubt as to what Measure Z Section 6 does, going to the next slide, the interveners in their complaint explicitly say that Section 6, and I should take the C rather than 3, contains an administrative procedure to determine whether an unconstitutional taking has occurred. So this is, again, a procedure that is meant to substitute for the traditional judicial route. And the county attorney in an October 24th, 2017 board meeting, and I can read the entire transcript from this relevant section if you want. I think the keywords are here. The county attorney emphasized that this is not about granting a permit. This is about a determination of existing rights, whether or not this has been a taking of a plaintiff's property right. So this is a very different process than we would normally have. So going to the next slide, the interveners have made a great deal in particular of Section 6B. As I mentioned earlier, we would have no problem if Section 6B was the only provision. But one of the reasons why they have focused on Section 6B is going to the next slide because of the California Court of Appeals decision in San Mateo County Coastal Landowners Association versus County of San Mateo. And in their view, this case is on all fours with the case before you on. This particular case dealt with an initiative in San Mateo County that amended San Mateo County's local coastal program. The case is very different, very outset from this particular case. And that was not brought by landowners. It was brought by 3 nonprofit organizations representing landowners and farmers. And one of the things that they complained about was that under this particular ordinance, if you wanted to develop new land, then the county would insist that the property owner, in return for developing the land, adopt either a conservation open space easement on the one hand or an agricultural easement on the other. These easements were very different than what I frequently think of as open space easements or agricultural easements, in that they permitted a great deal of different types of profitable uses for a property owner. But the three nonprofit associations said, making a facial challenge, the county cannot impose any type of easement here because that would be a violation of DOGGR. It would be an unconstitutional condition. And in the one paragraph that the interveners cite to, this is what the court said. That the appellants have not shown that this particular statute can't be applied in a way that would be constitutional. As the court started out by then pointing out, next, that these easements provide a variety of different types of uses. And in fact, until it was applied to a particular piece of land, we wouldn't know exactly what type of uses would be permitted because that was part of applying this easement provision to the property owner. The court went on to then note that, in fact, this measure had a provision which very, very similar to Section B in this particular case, that says that the ordinance shouldn't be applied in a way that would violate the Constitution or the laws of the United States. And then finally, the court said, take all this into account. The county has the flexibility to avoid potentially unconstitutional application of the easement requirements. When I look at this statute, what the court is saying is that you have an opportunity to apply this statute and decide exactly what you're going to require under the easements. Those easements permit a lot of economically viable use. And when you're doing that, keep in mind, by the way, that this provision says that you shouldn't apply the statute in a way which would violate the Constitution. And we are not arguing that Board of Supervisors or other administrative agencies should ignore the Constitution. All public servants frequently take oaths of office in which they're sworn to uphold the Constitution. And we would hope and believe that when expert agencies and boards apply statutes, that they do try to avoid, just like Section 8 of Measure A requires, that they would avoid violating the Constitution. But the key thing here is that there was a permitting process in this particular case that provided the county with the authority to contour the way in which it applied the statute, and that permitted them to apply it in a way which would not violate the Constitution itself. Here we have a very different type of a situation in what Measure Z tries to do through Section 6C, is to actually take a judicial determination and, rather than letting the court initially make that determination, set it instead to a political body. So just comparing the two measures, see on this particular slide. First of all, claims are very different. San Mateo, which is a general constitutional claim by nonprofit associations. Here, you actually have CRC and other property owners who are showing that the application of Measure Z today, or as soon as the temporary stay is lifted, would constitute taking. Second of all, in San Mateo, it was just a general challenge. Future easements may constitute unconstitutional condition. There was no easement in front of the court. Here we are making a facial takings claim based on the language of the statute, which is before you wrong. Third, in the San Mateo case, there were multiple economically viable uses permissible. In this particular case, there are none permitted to CRC. Fourth, San Mateo dealt with a traditional permitting variance process. That was what the court said that the property owners had to comply with. Here there are no permitting or variance processes. Fifth, There was a section 6B like section that was usable in San Mateo when the county applied its traditional permitting processes. Here there's also a section 6B. We have no objection to section 6B. Finally, in San Mateo, there was no section 6C, but here there is this form selection mandate. So we believe that the San Mateo case is not directly relevant. So with that as the background on section 6, what I want to do next is first of all talk about why we believe the CRC's claim is right for review, and then second of all why we believe that in addition to that, that section 6C is invalid. So first of all, in terms of rightness, there's really two issues here: rightness and exhaustion of administrative remedies. And in thinking about whether or not these principles apply, we think it's important to go back to first principles. So the concept behind rightness is to make sure that the court is actually addressing a real dispute. Not a hypothetical dispute where you have to guess at what's at stake, but a real dispute, and this Supreme Court made clear in policy. In your typical zoning case, again, where you have a permitting process, the reason why those are generally not right for review until after they've gone through the permitting process is that you're not sure how the zoning law actually gets applied. So looking at that zoning map, we don't know whether or not they're going to permit a number of lots there, or maybe half those number of lots, whether or not they're going to require more open space. Whereas in this particular case, there's no uncertainty. We have the language of the statute in front of us. The language of that statute says no new laws. Second question is exhaustion. And the purpose of exhaustion is primarily to avoid judicial interference with matters within an agency's special jurisdiction. The again is that if there's a regular permitting process, the court shouldn't interfere with the ability of the permit agency from applying its expertise and deciding whether or not the statute applies. So that's your typical case. But in this case, on the other hand, we're actually, through Measure Z, Section 6, asks a political board to, again, resolve a constitutional claim that is a judicial issue, and it would inevitably come back to the court in any case. And we believe, going to the next slide, that the Action Apartment Association case, and this is Action Apartment Association versus Santa Monica Rent Control Board, 94 Cal App 4587, is directly on point. So this particular case dealt with the city of Santa Monica's rent control ordinance. And the city of Santa Monica required all of its landlords to pay the tenants 3% interest on security deposits. And the landlords came into court and said 3% is more than we can make on our money. They can still give us 3%, and therefore this is unconstitutional. The city of Santa Monica argued, first of all, this isn't right for consideration. The Court of Appeal responded, it is definitely right, because the issue before the court is quite clear. It's whether or not you can demand that somebody pay 3% interest when they are not making 3% interest on their money. Second of all, the city of Santa Monica said, well, you need to exhaust your administrative remedies. And for example, one of those remedies was that there was a provision for adjusting individual rents, so that if you weren't getting enough rent, they could come in and adjust those rents. And Santa Monica said, we can deal with the security deposit issue through that particular provision. The court, actually going back to that last slide for a second, the court first of all did question the adequacy of that remedy, whether or not that could actually be used to deal with the security deposit question. But more importantly for this particular case, Court of Appeal went on, this is the next slide, and said even if that administrative procedure, up to a petition for an adjustment in the rent, were adequate, even if it were adequate, the court said no need for exhaustion of administrative remedies in this particular case. for all 5 of these reasons. This is a straightforward legal issue that the court can resolve. Second of all, this is a judicial question. This is not a question for the rent control board. This is a question of whether or not this is constitutional taking. That is a judicial question. Third of all, if we send it to the to the rent control board, it's not going to resolve the issue. This is likely to come back to us. And so sending it to them is unlikely to solve the dispute. Fourth of all, this is not going to impair the function of, in that particular case, the rent control board. They can still do their operation. And finally, and we think very importantly, to send it all the way to the board and then have it come back, according to the Court of Appeal and Action Department, would pose severe time and financial burdens on property. The court also, in addition to that, said there is an exception for important questions of public policy. That to the degree a court, by resolving a case, can help property owners generally know what their rights are, then that's also a reason to go forward and not require any type of exhaustion of administrative remedies, even if those remedies are proper. So for all of those reasons, going to the next slide, we believe that not only have we proven all the elements of a lupus claim, but in addition to that, that our claim is right, exhaustion is unnecessary, and that would be true even if the Section 6C is valid. But going on to the next slide, we believe the court should also declare Section 6C invalid. And going to the next slide, there are 3 reasons for this. The first one is one that Your Honor has already raised, which is that takings issues, constitutional issues, are judicial issues. And the board cannot adjudicate takings claims. Second of all, we believe that the provision is unconstitutionally vague. And third of all, that it's unnecessarily burdensome to property owners in violation of due process. Going to the next slide, this is the point again that Your Honor has already raised. We believe the board cannot adjudicate takings claims. Going to the next slide. The major reason is one that California and U.S. courts have noted in many cases. Boards have expertise in land use matters. Boards do not have expertise, and their expertise is of no assistance in adjudicating takings claims. Again, this is one of the holdings of the Action Department case. Going to the next slide. The reason, though, why the board is an inappropriate decision maker is not simply their lack of expertise and experience, but it's also that they do not have various other attributes of judicial decision makers, and those are the next point. They're subject to political pressure. Third of all, they have no experience in developing the type of constitutional facts necessary to make takings determinations and writing constitutional decisions that then can be reviewed. And finally, unlike courts, there's no separation of the governmental functions. The board, the very body which is meant to implement the act, also has to determine whether implementation of that act would be unconstitutional. And I could go on at length on particular judicial decisions, but going to the next slide, there's a number of cases. All of these are cited in our briefs, which emphasize that administrative agencies, in this case the board is acting as an administrative agency, are not competent to decide takings questions. Hensler is a California Supreme Court decision from 1994. Main question, actually stay on that first point up there. The Hensler case actually dealt with questions of statute of limitations. What was the appropriate statute of limitations in an inverse condemnation action? The plaintiff, as part of that, objected to having to pursue administrative remedies that they had for sort of general permitting issues. One of the reasons the plaintiff was concerned about that was the plaintiff was concerned that it might be that their takings challenge would be resolved as part of that administrative remedy. And the court said, don't worry. An administrative agency is not competent to decide whether its own action constitutes a taking. Now we go to the next point. This is also, as noted a moment ago, something the action department specifically said. Constitutional challenge to the regulation presents a dispositive question within judicial, not administrative competence. And third of all, there is the healing case that the California Supreme Court in the Hensler case relied upon. Says administrative proceedings are not the proper forum for consideration of takings issues. And I'll just go to the last point. These are actually not in our brief, but just in case you are once more than California decisions, the United States Supreme Court has also emphasized this point in a number of cases. We've included two of them on this particular slide, if you are interested in examining them. So that's the first point. This is a judicial issue. It is not a political issue for a board to make. Going on to the next slide, the second point is that Section C is unconstitutionally vague. And going to the next point, we believe that vagueness is a very important issue in this particular case. Obviously, vagueness is most typically brought up in connection with criminal cases. But the United States Supreme Court has emphasized in several cases, and the one that is most important in this case is actually not cited on the screen, but it's Village of Hoffman Estates. So again, that's Village of Hoffman Estates, and the citation is 455 U.S. 489 at page 419. And what the U.S. Supreme Court notes is that when you have a fundamental constitutional right, in that particular case it was dealing specifically with freedom of expression, but property rights, also a fundamental constitutional right. When you're dealing with fundamental constitutional rights, the Constitution demands clarity in the exercise of any authority over that particular right. That's particularly relevant here, Your Honor, because under the county's ordinance and their interpretation of Measure Z, the property owners have the obligation to actually figure out what type of exemption to ask for. That means we have to figure out what type of exemption we are permitted. And it means that we'll have to figure out what is the minimal amount of protection that the Fifth Amendment demands. That's going to have a chilling effect on property owners in actually asserting their rights, because we will have to go in trying to figure out what's the least we can demand, because we ask for too much more, then it might be denied. And then third of all, as the Supreme Court mentioned in the Greenhead versus City of Rockford case, when you have very subjective standards that can allow for arbitrary and discriminatory application, particularly when you're before a board of supervisors. And I should apologize, by the way, that we, in an attempt to actually reduce the amount of time I would need this morning, we have eliminated and combined some of the slides. So as you're following through the slides, they might not always totally coincide. So those are the core principles why due process is important. So going to the next slide. There are a variety of sources of vagueness, we believe, in Section 6C. One is that, as you mentioned already, Your Honor, Section 6C says the board may grant an exemption, but it doesn't say when it should or when it shouldn't, which can leave it to the board of supervisors to determine, and it could mean that it would differ depending on particular property owner, whether the property owner has a lawyer, whether or not the property owner is large or small. Second of all, we're not quite sure what a permissible exemption should look like. There's no standard for this. I think of this as the apples, oranges, and bananas problem. That it might be that an exemption would give you a certain number of wells. It might say, no, what we're really going to care about is how much you can produce. It might be that it will be, well, we'll let you produce for a set period of time. So it might be a property owner comes in and says, we would like to drill one well, but we're going to drill that well using various techniques that can maximize production out of it. It might be that a person of interest, like interveners, might come in and say, no, we actually don't like that production approach. We would prefer that you do 3 wells, but use more conventional production. It might be that maybe another person of interest would come in and say, no, what we'd really like is maybe you should have 5 wells, but we'll only let you use them for 10 years. How does the Board of Supervisors decide which of those approaches to take? And furthermore, which of those is the minimum needed in order to avoid a constitutional taking claim? And finally, recognize that what Measures he does is simply incorporates takings law and says that the exemption has to be the minimum necessary to avoid a taking. The the Ninth Circuit Court of Appeals in the Hunt versus City of Los Angeles case criticized Los Angeles for doing something very similar in a free speech case, where they limited free speech on the Venice Boardwalk. But in order to try to avoid any type of First Amendment problem, they knew there was a case out there that said that actually there was a First Amendment problem with what they were doing. And so they said, okay, well, we're going to ban it. But if you find that the speech actually falls within this case, the case, then that's permissible. And the Ninth Circuit said, that's vague. You can't simply take a legal standard that a court might apply and incorporate it in an ordinance. Going to the next slide, just want to emphasize it again. I think Your Honor is quite familiar with this, but when we first, let's assume the CRC had to go through this particular process. We would first say there was a Lucas. We think Lucas is really quite clear. But then on the next step, figuring out what the exemption would be, at that point you would be outside of Lucas. You would be dealing with penn-central. What's the minimum necessary in order to be penn-central? And the Supreme Court in the Lucas case said, well, outside of a Lucas statement, court is generally eschewed any set format, preferring instead to engage in essentially ad hoc factual inquiries. That's what Measure Z would require the board to do in this particular case. And going next. Yeah. What penn-central requires, and I've just set this out here, is a balance. So you look at the economic impact on the property owner. You look to see what are the type of distinct investment-backed expectations there are, the degree to which it interferes with that. What's the character of the governmental action? This is a difficult balance, again, even for courts to engage in, but with courts that have experience in these types of determinations, that are objective decision makers, under Section 6C, we would be requiring the Board of Supervisors to entangle themselves in these types of constitutional determinations. Going to the next slide. And again, I think this is important to emphasize, under Section 6C, the Board of Supervisors would not just have to decide whether or not something is permissible in the penn-central. They would have to decide what's the minimum necessary in the penn-central. How much can you actually reduce somebody's property value? How much can you actually interfere with an investment-backed expectation? Before you cross that line, we have to go at the minimum line. Property owners who are going in and asking for an exemption would have to ask themselves this question. The Board of Supervisors would have to ask what's the minimum necessary. And if a Section C exemption were challenged and then brought back before Your Honor would have to ask not the question of whether or not this exemption is constitutional. You would have to ask, could the board have asked for less? Could the Constitution demand less than this? And if so, send it maybe back to the Board of Supervisors to demand less of the property owner than they granted the first time around. And as we mentioned in both our opening and our reply briefs, I just want to give some very quick examples of this. I think if you take this type of language and apply it to other settings, you see how troublesome this is. Let's go into the next slide. Imagine, for example, that there was a statute passed that said that no immigrant children can attend public school except to the minimum extent necessary to comply with the equal protection clause. And the local school boards have to decide that. Or going to the next slide, that no person charged with murder can be provided tax-funded or legal assistance except to the minimum extent necessary to avoid a violation of the Sixth Amendment. We have looked for a case that's like Section 6C that has this type of language. And I don't know whether it's fortunate or unfortunate, but we haven't found one. And so all we can ask is this type of language permissible? The closest we've come, going to the next slide, is again the Hunt decision, which I mentioned a moment ago, the Ninth Circuit decision, where the city of Los Angeles banned the sale of merchandise on a public boardwalk, except that they did take this one provision from a case and said, well, to the degree to fit within that, we're going to permit that because that's necessary to comply with the First Amendment. And that particular case, the Ninth Circuit, going to the next one, rejected that type of approach. Although we cannot find a case that has anything like Section 6C, we think it is unconstitutional to take this type of minimal approach for several reasons. Number one, again, it chills the property owner's right to enforce their property because it forces us into a decision. Because we have to go in there and say what type of exemption we want.
And doesn't that type of decision arise whenever a property owner is making some kind of an application for a variance or a use permit?
It definitely does, Your Honor. What's different here, though, is you're absolutely right. When you're going in and trying to figure out how much density, how dense your property development is going to be, you have to make that type of determination. And you decide how much open space to provide. You have to make that type of determination. What is different here, though, it's a determination based on a constitutional right. The Fifth Amendment protection of property rights. And what we're having to ask ourselves here is, what is the minimum necessary in order to protect our property rights? And that means that if we guess wrong, we go too high, we don't have an exemption. We go too low, we violated our own property interests. So what is important is that line that the property owner has to sort of guess where it is and come as close to it as possible in order to make sure we're going to get an exemption, is the minimum constitutional protection permissible. So again, thinking about from the First Amendment standpoint, it would be like saying to somebody, you have to guess at the minimum amount of free speech you're entitled to, and that's what you should be asking for. Or the children of immigrant workers, they would have to ask, what's the minimum amount of public education we're entitled to? Or the person who is before a court with a criminal charge, what's the minimal amount of counsel we're entitled to? In all of those cases, what makes it important is that you are pushing the lines on the constitutional right to the maximum degree. Going back to that last slide. So part of it is that. The other thing is that under Penn Central, remember Penn Central has 3 different requirements. And one of the things that you look at in Penn Central is the character of the governmental action. What Section 6C is doing, its very character, is trying to minimize a constitutional right. And that in itself raises problems under Penn Central. The authors of Measure Z could have written a variety of exemption processes. They could have said, you're entitled to an exemption if you can show that you're going to protect water quality while also ensuring people's property rights. They could have said, you can get an exemption if you can show that you're not going to harm the environment while protecting property rights. But the focus here was not on any substantive concern. It was on, what we'll do is we'll give you the bare minimum. We'll give you the least that the Fifth Amendment and the 14th Amendment and the California Constitution requires. And that is ultimately, we believe, is another cause for invalidating Section 6C. But then turning to the last point, we also believe that it violates due process. And the key case here, going to the next slide, is the California Supreme Court's decision in Birkenfeld versus the City of Berkeley, which is at 17 Cal 3rd, 129, a 1976 decision of the California Supreme Court. In this particular case, you're dealing with a Berkeley wind control ordinance. And the California Supreme Court started out by recognizing that inevitably, by the nature of the wind control ordinance, there would be some landlords that would not get an adequate rent for their apartments. And the City of Berkeley actually had established a process for adjusting permissible rents. But the California Supreme Court said that it was very important that that provision that permitted landlords to get a rent adjustment so that they would avoid any type of a constitutional taking, that had to provide adequate protection for the landlords, and that protection to be adequate had to minimize delays and burdens. Right? Had to make sure that the decision would be a prompt one and that it would not be overly burdensome. And what we've set out on the left-hand side are the reasons why the California Supreme Court decided that the Birkenfeld ordinance was unconstitutional. First of all, it applied to many or most landlords, so that there would be a lot of landlords that would have to use this procedure. Second of all, it required that each landlord go in for an individual rent determination. As a result of all of that, the California Supreme Court believed that there would be a high volume of applications and that would result in delay. And one of the reasons why it was likely to result in delay was that every single one of these had to be heard before the rent control board, and that there was no time limit given for decision making. Compare that to Measure Z. First, just like Birkenfeld, Measure Z applies to many or most mineral right holders. And in fact, although we do not know exactly how many mineral right holders there are, what we do know, and this is in the record, is that there were 300 mineral rights assessments last year, so that means 300 separate mineral right holders were assessed property taxes. Those mineral rights presumably were valuable, else they wouldn't pay property taxes, and so presumably all of them will want to seek an exemption. Going to the next point, Measure Z, just like Birkenfeld, requires individual applications and individual exemptions. It does not permit the board to set out general exemptions. Every single person has to go in with an individualized application where they will have to submit all the evidence necessary to show that their requested exemption is the minimum necessary under Penn Central. You have to throw in all the evidence that Penn Central would look like. Then on the third point, that means that there's a high volume of applications likely, and these are likely to result in delays because, going to the fourth point, there have to be hearings before the Board of Supervisors. The county is probably later going to say, well, we have to look at the ordinance. If anything, the ordinances that are being proposed right now make it even more burdensome because first there'll have to be a hearing before a hearing officer, and then a hearing before the Board of Supervisors. And just like in Birkenfeld, it imposes, going to the next and final point, no time limit on decision making. So for all of these reasons, we believe that not only does the court have the ability to proceed to the facial takings claim because there's no ripeness or exhaustion issue, but furthermore, we believe that Section 6C is unconstitutional. So going to the last slide, this is the exact language of Birkenfeld versus City of Berkeley, that just like the review process in Birkenfeld, we believe Measure Z's exemption inherently unnecessarily precludes reasonably prompt action, except perhaps for a lucky few. Going to the next slide. This is the relief, therefore, that we have asked for at the moment, a declaration that Measure Z affects the facial taking of CRC's property, and a declaration that Section 6C is invalid. And then, as I promised earlier, going to the next slide, I have to end with Oliver Wendell Holmes again. The interveners have emphasized that we're dealing with an initiative here. And initiatives are critical because they are the voters' will. And CRC agrees with the importance of initiative, the importance of voters being able to say what they believe laws should be. But voters, just like all of us, are in danger of forgetting, just quote Justice Holmes, that a strong public desire to improve the public condition is not enough to warrant achieving the desire by a shorter cut than the constitutional way of paying for the change. And that's what we believe is lacking in this particular case.
Thank you.
Thank you very much.
Mr. Tonight?
Your Honor, yes, I think I'm going to speak next. Can I just ask, we take our morning recess a little early?
We can recess for 15 minutes.
Remain seated, come to order. Court is again in session.
Right, one evening, we're going to come to record of emergency cases. But before we get started, I want to ask all counsel, and this goes back to our preemption argument yesterday. If you will prepare, if you can do it jointly, great. I realize there might be some disagreement, so separately explain. But I'd like to have a chronology tracking the statutory provisions, enactments, and changes. Not the least of which is Public Resources Code Section 3106, 3106B, what they have, a chronology tracking the evolution, modification, and addition of the code sections, including the safety and DOGGR regulations to the extent that you can locate that information, and with citations as to source.
Your Honor, I think that because this is a very specific request, that we should be able to work with the interveners and county council to provide you with what should be just objective information.
Yeah.
So we'll work to do that.
Thank you. All right. Yes, pardon?
When will you work on that?
Well, we have a few other things on mind. On the other hand, I'm also certain that you will delegate it to your subordinates. So, as soon as you can. Don't do it.
Within reason.
Yeah, don't sacrifice your presentations. Okay. You're right. All right, Mr. Dinser.
All right, thank you very much, Your Honor. Again, my name is Jeffrey David Dinser, and I represent Chevron USA Inc. and the other plaintiffs identified in the caption that has the case number ending in 3978. And I am here this morning to address Chevron's declaratory relief claim for a facial take as a result of the enactment of Measure Z. First off, and as a matter of introduction, I think it's important to note that the only evidence before the court shows that a facial taking of Chevron's exclusive property rights has occurred. And that based upon that evidence, there is no question that the prohibitions in Measure Z eliminate all economically viable use of Chevron's property. I think it's also very important to note that notwithstanding the opportunity to do so, neither the county nor the interveners offer any evidence, let alone contrary evidence, to dispel the notion that Measure Z eliminates all economically viable use of Chevron's property. In particular, the no new wells prohibition that we see in section LU 1.23 is repugnant to the Constitution. The outright ban on any new wells will cause an immediate and catastrophic decline in production in the San Ardo field. And as I'll explain in more detail, without new steam injection wells and production wells, Chevron's only oil field will immediately lose its economic value. And the plain language of Measure Z also prohibits steam injection for enhanced oil recovery, a vital component of continued operations. And I know that we've heard that from the county and the interveners that steam injection would be permitted. We believe that that is contrary to the plain language of section 1.22 of Measure Z. Moreover, even if Measure Z allows steam injection for production, there's no way to dispose or store the produced water that is generated as part of the oil production operations. Because the oil in San Ardo has a high viscosity, it is necessary to inject produced water as steam into the formation. And without steam flooding, the steam chest will quickly collapse and it will lose all value. And the phase-out ban on the injection and impoundment of produced water for storage and disposal immediately tanks the value of the San Ardo field. All water injected and impounded at San Ardo, from disposal wells to constructed wetlands, is produced water. And the sheer volume of that water makes it completely uneconomical to dispose of it in any manner other than reinjection. No rational business will continue to invest capital into an oil field with the threat that all operations must cease within 5 years, particularly when the abandonment liabilities will be accelerated to the present. The county's interpretation of the no new wells and no produced water injection and impoundment prohibitions are flatly wrong. And I know this was something that was discussed at length during the preemption arguments, and I'm not going to belabor it, but no new wells, Your Honor, means no new wells. And you heard from the interveners and the plaintiffs, there is concurrence on that interpretation. And no disposal of or storage of produced water means no steam injection nor disposal of any produced water. That includes even purified water, because it's still produced water. Now, I'm not going to retread on Professor Thompson's very elegant presentation on the authorities involved in facial takings, and in particular the Lucas case. But I will point out that the facial taking standard is actually pretty straightforward, as distinguished, for example, from a Penn Central analysis. We learned from Lucas that the cases say repeatedly and unmistakably that the test to be applied in considering a facial takings challenge is straightforward. The statute regulating the uses that can be made of property affects a taking if it denies an owner economically viable use of his land. And the Ninth Circuit in the Tahoe Sierra case amplifies this point. It's a more recent, obviously, decision. In facial takings claims, the court's inquiry is limited to whether the mere enactment of the regulation constitutes a taking. Now, I think it's important just to point out that based upon the Pennsylvania coal case as well as the Brawley case, which we've cited in our papers, that oil is a property right subject to constitutional protection. California and federal courts have universally and consistently recognized a landowner's right to extract natural resources from a property. Oil is a property right protected by the Fifth Amendment to the Constitution and the California analog. So there's no question that since Measure Z devalues the operations at the oil field in San Ardo, oil fields in San Ardo, it eliminates all value if it goes into operation, that there is a facial taking that occurs. Now, before we get into some of the evidence to support the claim, the declaratory relief claim, I think it's important that we spend just a moment looking at the language of Measure Z, the plain language of Measure Z, and understand what its effects would be. And in order to understand the impact of Measure Z, one must start with the plain language of the initiative. California Cannabis Coalition case teaches us that our primary concern is giving effect to the intended purpose of the provisions at issue. In doing so, we first analyze the provision's text and their relevant context, which is typically the best and most reliable indicator of purpose. And in the Lesher case from 1990, the court concludes, absent ambiguity, we presume the voters intend the meaning apparent on the face of an initiative measure, and the court may not add to the statute or rewrite it to conform to an assumed intent that is not apparent in its language. And from 1992, the Fonte versus Upright Inc. case, the California Supreme Court articulated the standard that ballot materials can help resolve ambiguities in an initiative measure, but they cannot vary its plain import. And I think that runs to the point that the court was discussing with counsel yesterday concerning whether or not the county council's interpretation of elements of Measure Z should be given as much deference as the county is advocating. Now, Measure Z contains three prohibitions that facially take Chevron's property. Number one, Measure Z immediately prohibits new wells, and that is a very big problem with the measure. Number two, Measure Z prohibits the injection of produced water for enhanced oil recovery. That's the steam injection process. And number three, the measure prohibits the injection of produced water for storage or disposal. So let's examine each of these prohibitions more carefully. If we look at the no new well prohibition, what it says is, quote, prohibited land uses. The drilling of new oil and gas wells is prohibited on lands within the county's unincorporated area. And then we have a definition in the same section which says oil and gas wells means wells drilled for the purpose of exploring for, recovering, or aiding in the recovery of oil and gas. And we know that the interveners, the folks who are the proponents of the initiative, have told this court unequivocally that what they said, no new wells, that meant no new wells, no new holes in the ground. And that is the way we read the initiative. Now, the county has a different take on this, and as the court pointed out, that interpretation may be somewhat self-serving because they are obviously concerned that no new wells goes too far. If you compare the measure, the drilling of new wells and gas wells is prohibited on all lands within the county's unincorporated area, With the county's interpretation, the prohibition applies only to drilling wells exceeding the number operating at the time the measure becomes effective and would permit replacement wells. You find that the county's interpretation is totally inconsistent with the language, the clear language of the measure. The measure says nothing about replacement wells. The second prohibition of Measure Z is with respect to the steam injection. But let me back up. When we talk about no new wells, let me be clear. We're talking about no new wells that are necessary for the operation of an oil fields like San Ardo. So that means you cannot put any vertical production wells in. You can't put sidetrack wells in because it has a new bottom hole. You can't put horizontal wells in. You can't put new UIC Class 2 disposal wells in. You can't put temperature observation wells in, which are, of course, necessary to understand the temperature of the steam chest. And you can't put the steam injectors in, the steam flight wells in. None of these wells are allowed under the strict interpretation of the measure. So now we move on to the second prohibition, which is of concern, and that is the prohibition of steam injection for enhanced oil recovery. And again, this is a section LU-1.22 of Measure Z, and it says, prohibited land uses. The use of land in support of oil and gas wastewater injection or oil and gas wastewater impoundment. And then it has the definitions below it, and it says oil and gas wastewater injection means the injection of oil and gas wastewater into a well for underground storage or disposal. All right, let's stop there for a moment. You understand from the Tubbs Declaration and other declarations that have been submitted by some of the other plaintiffs that it is absolutely vital to removing viscous oil, like the type that is in San Ardo, that you must build this steam chest in the Lombardy Formation. And it takes a long time, a lot of capital is spent to produce that steam chest. And the steam chest allows the oil to, it changes the chemical nature of the oil such that the viscosity goes down. It lowers the viscosity, it becomes more unlike ketchup and sand, and more like more watery. And it then allows the oil to move with the water in the formation up into the well screens, either if they're horizontal or they're vertical. And we can pump it out. And then, of course, you know what we do with the water afterwards and the oil. The notion that we would put steam into the Lombardy just to simply pump it out makes no sense. The whole point of a steam chest is that you're storing this steam. And in fact, as I'll show you in a moment, the objective is to lower the pressure, take as much water out of the Lombardy as you possibly can, inject steam in there, and let the steam stay. And the steam will stay. You know, you have to continuously put more steam in because some of it will be pumped out. But the objective is to store it down there, and so that heat continues to chemically react with the oil and lower the viscosity, thereby making production much easier. The notion that the steam injectors does not fall within the prohibition set forth in LU 1.22 is misplaced. It specifically says that you cannot put produced water by injection into a well for underground storage. And that's exactly what the EOR, Enhanced Oil Recovery Systems, do. analogous federal and state regulations where the term storage is defined. For example, in the Resource Conservation and Recovery Act, it's a federal law which governs how we transport, store, and treat hazardous waste. But it has very strict definitions about what storage means. And it says, this is what the regulations say, it says storage means the holding of hazardous waste for a temporary period at the end of which the hazardous waste is treated, disposed of, or stored somewhere else. Well, that's exactly the right definition, of course, because that's what storage is. You're putting it in a chest, leaving it there, and then maybe some other time later you'll pull it out, or not. And the state regulations, the corresponding California regulations, have a very similar definition. Storage means the holding of hazardous waste for a temporary period of time, at the end of which the hazardous waste is treated, disposed of, or stored somewhere else. I mean, this is not a novel concept. And I realize that the questions that the court posed to Mr. Tanaka the other day on this issue created maybe some confusion, but there should not be any, because the term storage means what we all believe and understand it means. So, lest there be no misunderstanding or fudging of the interpretation, the fact is that section LU.122 prohibits EOR operations after the 5-year amortization. Measure Z's prohibition on injecting produced water into impoundments or into the formations for disposal is equally problematic from a takings perspective. Then we go to that section and we see it says oil and gas wastewater injection means the injection of oil and gas wastewater into a well for underground storage or disposal. And oil and gas wastewater impoundment means the storage or disposal of oil and gas wastewater in depressions or basins in the ground, whether man-made or natural, lined or unlined, including percolation ponds and evaporation ponds. And oil and gas wastewater means wastewater brought to the surface in conjunction with oil and natural gas production, including flowback fluid and produced water. And I want to spend a moment on that term, produced water. Produced water is a term of art in the oil industry, and those two words mean water that is extracted from the ground for purposes of oil production. And everyone who has been to an oil field or has any knowledge about oil production understands that that produced water has to be disposed of in some manner. And the most typical way that produced water is disposed of is into formations that are aquifer exempt in the ground. Now, Measure Z makes no exception for different types of produced water or treated water, as the county and interveners to a lesser extent argue. Again, if you compare the language of Measure Z, it says oil and gas wastewater means wastewater brought to the surface in connection with oil and natural gas production, including flowback fluid and produced water. It doesn't say anything about you can put treated water back into the ground. There's nothing in there about treatment. And the county's interpretation that you can treat the wastewater and then put it back in the ground is problematic for several reasons. least of which is, what does it mean by treated? I mean, if you take the definition of the term treated, to mean what it means in the regulatory context, by virtue of, say, Drinking Water Act, RCRA, all of these other environmental and public health statutes, the word treated means you are changing the chemical nature of what you have. And by definition, is the moment that produced water with the oil goes into a water separator unit, what they call a free knockout system, the minute that happens, the water's treated. So then you could just take the produced water and put it right back into the ground, which is what we're doing. And that would give no meaning whatsoever to Measure Z, if that were permissible. Or does treated mean that it has to go through some kind of other chemical processes? Or does treated mean that it has to go through an RO plant? We don't know. And the county certainly doesn't tell us, nor is it qualified to make a determination as to what kind of treatment is necessary to make the water suitable to put back in the ground under Measure Z. Equally problematic is the intervener's assertion that nothing in Measure Z suggests that produced water which is treated by reverse osmosis process and sufficiently purified would fall within the ban on wastewater disposal. Again, that's just not in the measure. There's nothing that says anything about reverse osmosis in the prohibition. It doesn't say, you can't put produced water back in the ground unless you put it through a reverse osmosis process and purify the water. Had it said that, then I suppose we would be allowed to do that. But that's not what it says. And I think it's incumbent upon the court to be restrained from attaching these qualifications onto the strict language of the measure, which, as I indicated in the cases that we discussed previously, we believe is prohibited. And it's not just plaintiffs that don't find these qualifications, these treatment of purified water qualifications in the measure. The county's own expert, Mr. Burzlaff, during his deposition, I asked him, I said, is any treatment of the produced water exclusive of treatment to a potable water condition dealt with in Measure Z, such that the treated water could be put back into the ground for disposal or storage? And his answer was quite clear. I don't recall any discussion of treatment processes in Measure Z. Well, he's right. There isn't any. Chevron and the other plaintiffs, as I'm sure that the court understands, employs engineers and chemists and geologists and hydrogeologists, people who study petroleum extraction and processing. And they understand what the regulatory framework is because they deal with it every day. So this notion that we can continue to operate our RO plant, as was suggested by Intervenors Council, and just purify the water and then dispose of it into the wetlands, is belied not only by the strict language of the measure, but it's also belied by the fact that the water that comes out of the RO plant is considered wastewater by the state of California. You can't just take even purified water that comes out of an RO plant and dispose of it onto the ground in the state. You can't do that without a permit. And in fact, when they were constructing the reverse osmosis facility, an application for such a permit was sought from the state of California. And the staff report from the staff report from that analyzed that application says the following, and this is from 2005. Chevron Texaco still wishes to discharge highly treated produced water. Again, produced water, the same water that's prohibited under Measure Z, Section 1.22, to land. Treatment will include filtering, water softening for steam only, reverse osmosis, and neutralization. Following treatment, the produced water will flow through a constructed post-treatment surface wetlands to percolation ponds. And shortly thereafter, in fact, the Regional Water Quality Control Board issued what's in the vernacular called a WDR. It's a waste discharge requirement permit. It says, therefore, it is the decision of said Director of Planning and Building Inspection that said application for an administrative permit be granted as shown on this attached sketch and subject to the attached conditions. And that's the WDR that regulates the discharge of the RO produced water to the wetlands. And just so the court has, I understand, I know Mr. Boutros showed this slide before, but I'd like to spend just a minute more on it. So what happens is the water from the RO, that's that clean water that we showed you in the bottles, the last bottle. It goes into a wetland. There are 3 wetlands at the San Ardo field. One they keep dry, and then they dispose of the water in the other 2, and then they rotate them to keep the vegetation fit. And then after the water settles into the wetlands area, it then flows into what are called percolation ponds. And these percolation ponds are they're essentially recharge ponds. I don't know if the court is familiar with this concept, but in the highlands around all over California, in order to avoid losing river water or streams that would otherwise flow out into the ocean, we divert water into these recharge ponds so that this water settles into the ground, raises the groundwater table, which then, of course, we can use that water later on for beneficial uses. And that's exactly what happens here. The water recharges the Salinas watershed. And it's not an insignificant amount of water. We're talking about 520 million gallons of purified water is released into the Salinas watershed every year. And that is a huge beneficial use that farmers can use, and that can be used by mutual water companies or utilities that produce water for commercial and residential uses. Now I want to change gears here for just a moment, because I promised the court we were going to get into some evidence, and I want to get to the evidence, the uncontroverted evidence. But before I do so, I think it's important to note that there was some discussion earlier on in this case about whether or not evidence should be considered in connection with a facial take. And we would submit that the Supreme Court has settled that issue in the Keystone case. In fact, in the Keystone case, the court concluded that the development of a factual record in a facial challenge is critical to its success. The court wrote that the record is devoid of any evidence on what percentage of the purchase support estates, either in the aggregate or with respect to the individual estate, has been affected by the act. This was a coal case. It's a 50-50 case, and they wanted to make sure that enough coal was left in the ground to keep the buildings up, the structures in their integrity. And the court said, we don't have any evidence to make a determination as to whether this is a take. You have to come back with evidence if you want to establish a facial take. Instead of trying to produce evidence in this case to dispute the conclusions that our experts and recipient witnesses have testified to, the county and the interveners instead choose not to put any evidence into the record, say Mr. Bird's declaration, but he doesn't address takings at all, and instead result to just objections. And then what are their objections? Their objections are relevance. Well, the Keystone case makes it clear it's clearly relevant information as to whether or not the measure, by its plain terms, will eliminate the value of the asset. And then the other objection they make is that it's a legal conclusion. All these declarations have legal conclusions. Second.
Your Honor,
Yes,
we're
Ms.
not
Hunt.
arguing our objections, we've been sitting here listening to a lot of highly objectionable material presented in these arguments. If the court wants us to argue objections, we can do that, but I would ask Mr. Windsor to move on.
And specifically, you're referring to,
The objections, his categorization of our objections right now that he's talking about.
you can argue the relevance of your presentation. This is a question. This is partly why the court is unable to move on objections at the outset of the case. Because the theories of relevance have not been articulated. That's essentially what I believe Mr. Pinzer's attempting to do. And likewise, during intervenors' presentation, we argued the principles on which they were not relevant to this inquiry. You know, one of the early questions that was raised in the case before this trial started was whether and to what extent evidence would be permitted in the facial takings. And the Keystone case does indicate that some is necessary. Now, I have heard a lot of talk about Mr. Burzlaf's interpretation of measures, and that I'm not even giving any weight to. He doesn't interpret measures, the court does. In terms of it went a bit far afield in talking about basically the beneficial effects. I say again, talking about Mr. Burzlaf's presentation about 520 million gallons of purified water going into the county, recharging the water table and water supply technically is not relevant for this requirement. But in his presentation, he was attempting to set forth why some of this evidence is admissible and because the nature of the proceedings certainly interveners can argue in opposition. And they argue in response to his comments.
I understand that, Your Honor, but we would have argued evidentiary admissibility throughout these presentations if we had known the court wanted to hear that. To the extent the court is intending to rule on our evidentiary objections based on the arguments in the court, I would ask that a certain amount of time be set aside for us to address these evidentiary objections, which we believe preclude a good deal of argument.
Give me an example of what you're talking about.
Well, for instance, the extent of the factual data that is being argued here, how many gallons of water, the unchallenged expert declarations as to the impacts and measures needed. Remind the court we were not allowed to conduct discovery during this specific case. So basically, we've got a record loaded with unchallenged expert declarations. We've got a record loaded with evidence that may or may not be relevant or applicable, but may not even be accurate. And I don't have in front of me my evidentiary objections.
There was nothing to preclude interveners or county from presenting the evidence. In fact, I think county did present some evidence in the form of Mr. Burzlaf's declaration. Please bear in mind the distinction between discovery to take depositions of an opposing side's declarants and the ability of the county or interveners to present evidence of their own. And that was never, the court has never precluded anybody from presenting evidence respective positions. There are issues which do require the presentation of evidence, and the Keystone case is a classic example. Background evidence as to what the nature of the geologic deposits are, how the oil, as a practical matter, can and cannot be extracted, are important on the questions of preemption, on the question of standing, such as fracking unnecessary in Monterey County, may deprive the petitioner plaintiffs here from having standing. Whether the takings, whether the regulation affects by its enactment a complete loss of the economic viability of a piece of property. It requires some evidence, doesn't it?
It requires evidence depending on the nature of the proceeding. We did submit evidence consistent with our understanding of the scope of the issues to be addressed here. I don't believe that it is proper to require, this is in the nature of a trial proceeding, correct?
That's what we're hearing.
Well, if we were to have only submitted opposing declarations with no discovery, we're really talking more in terms of a summary judgment that you would be hearing. That's why discovery was important. With regard to the economic impact of this, yes, I mean,
Well, but
evidence,
wasn't it interveners that requested that there be no discovery in these proceedings? Am I mistaken?
Your Honor, which is also why we've objected to the scope of the evidence submitted. No discovery was requested based on the scope of the issues and the scope of the review allowed during this phase of the proceeding. What's happened since then is that the record has been packed with all kinds of factual evidence that we contend is inadmissible for purposes of the scope of the review, not to mention that most of it is included in, a lot of it is included in requests for judicial notice, which is not proper for the court to be, as I'm sure the court knows and the court has already indicated, considering the content of that. I just wanted to stand up and make clear that
Colleagues, that you know, if you want to take a look at it, go ahead.
okay, I've been handed a copy of a quote from the case management conference statement, which says, I assume this is quoting the court, Your Honor. I don't think discovery on the validity and preemption issues is necessary at this point. And all we're saying is our understanding of that would preclude a good deal of the evidence that we've been listening to for the last several days here. To the extent, all I'm saying is to the extent the court wants us to argue these objections, we ought to give them an opportunity in a fuller forum to have done that. And we would have been doing it before.
Why don't we hold the proceedings now, and I'll go through your objections one by one.
I'm not asking the court to go through them one by one. Not suggesting that. It's just that when Mr. Dinser stands up and argues that our objections are meritless, that's not what we were expecting to occur during these proceedings.
Well, frankly, I just took those comments as underlying his argument as to why it is what, why it is admissible. But I want to underscore, you know, the nature of these proceedings did require the presentation of some evidence. And saying that there was to be no discovery is not the same as saying that you're precluded from producing any evidence.
I understand that, and we did produce evidence consistent with what our understanding is of the scope of the proceedings and the scope of the standard review to be employed during this phase.
Thank you.
All right, Your Honor, and I'll move on. So,
Here's, I would like you to focus on the following. When, if this measure is enacted, the Chevron, which has operating oil operations, when does Measure Z eliminate all economic viable use of its property? Because the evidence that is before you does not indicate or at least there's a question in the court's mind about how soon that comes into effect. Clearly, the wastewater injection and impoundment provision has a 5-year delay.
yes, Your Honor.
But there's also a no new wells prohibition.
So let me, I'm going to go right to that right now, okay? That's right where I was going to go. So let's put up the next slide. And let me start by saying that we believe the uncontroverted evidence establishes that a facial fading occurs immediately because of Measure Z. And in particular, I want to focus on the no new wells provision. A little history, just a little bit of history is helpful here. In 1945, within a Texas company, which is the predecessor to Chevron, entered into an oil and gas lease. And what that oil and gas lease said is that the leased land for the term of 20 years from here and after the date thereof, and so long thereafter as oil and gas or other hydrocarbon substances are produced in paying quantities from the leased land. So this lease continues on today and will continue on as long as Chevron continues, Chevron or its predecessor, or its successor I should say, continues to produce hydrocarbon substances that are in paying quantities, okay? And in 1949, a few years later, they went to the county and they got this conditional use permit, which is a very broadly worded permit, and it says allowed, it says the county is allowing the applicant to drill for and or remove oil and gas and other hydrocarbon substances on the property. Okay. Let me start off by going to the county appraiser's assessment of when the impacts of Measure Z would be felt. And this is a document that was generated by the county supervising appraiser in connection with the ballot, the Measure Z ballot, and it was part of the materials that were submitted by plaintiffs. And this is what he said. If the oil companies were not allowed or banned from drilling new wells, and they could not displace the wastewater that was produced from the wells, the oil companies would be effectively shut in quotes, and would most likely end production within a very short time. It would be estimated maybe 3 to 6 months from the effective date of the initiative as it is currently written. That's the county saying that. So you ask me, how quick does this Measure Z eliminate the value? Shut in means done. That's the way I understand it. He's saying 3 to 6 months.
There's two parts to what he's saying. One is banned from drilling new wells, which is a ban that comes into effect immediately. The second part is not displacing the wastewater that was produced from the wells, which would seem to fall under the second segment of Measure Z that has a 5-year delay.
I understand that, Your Honor, and I fully appreciate what the court's concern is there. But what I'm saying is that the county appraiser did an analysis, and he believes that both of those taken together will shut the operations down within 3 to 6 months. That's what he says. Those are his words, not mine. And I would cite to testimony from Mr. Berzloff's deposition that since the court is giving no weight to it, I will move on beyond this slide. And
I'm frankly not sure how Mr.
okay, Your Honor, I know.
I'm not sure how Mr. Berzloff's deposition even got taken, frankly. He's a misleading participant. That's it. Go ahead.
All right. So now I want to come back and explain why this no new well prohibition eliminates value in the field. Totally eliminates the value in the field. Very quickly. As Mr. Tubbs testified in his declaration, the only way that you can get the highly viscous oil out of the oil field is by building a steam chest. And as you see here from 2009, the steam chest. Hold on 1 second. No. There you go. And you see how it grows. The reason it's growing is two things are happening. One, new steam injectors are being put into the San Ardo field. And number two, new production wells are being put into the San Ardo field. Both of those activities will be immediately prohibited if Measure Z goes into effect. There's no question about that. Now, if Chevron is not permitted to continue to put in the steam injectors and the producing wells, the steam chest will collapse. And we know, so let me explain from this diagram a little bit. You can see that the Lombardi formation actually has 4 different zones in it. And the yellow, it represents a snapshot of the steam in the Lombardi. And the green area represents areas where the pressure is at or above 100 psi. When the pressure gets that high, you can't really generate steam that's hot enough to establish a steam vacuum. Okay, so what ends up happening is the steam just essentially is quenched by the water that exists in the Lombardi. So 2 things have to happen. You constantly have to be putting in new production wells to get that water out of the ground, to get the pressure down to 80 or even less inside these zones. And then you have to put in new steam injectors in order to make the steam chest grow and to maintain it. You have to do that. If you don't do that, the steam chest will collapse. Horizontal representation of the steam chest within the Lombardi Formation showing how the native water in the formation provides a constant influx of cold temperature and higher pressure that can cause the collapse of the existing steam chest. That's out of Mr. Tubbs' declaration. And Mr. Tubbs testifies in the same paragraph of his declaration that if Chevron is prohibited from adding or replacing wells that are critical to prevent the continued encroachment of water into the steam chest, then Measure Z's drilling prohibition will result in the collapse of the steam chest at the San Ardo field. It is critical that the steam chest constantly remain infused in order for continued operations at the San Ardo field to be viable. And again, this declaration is uncontroverted.
The question is, how immediate, given that there's a 5-year phase-out period, but prohibition,
Okay.
5-year phase-out period on injection and storage or around it, but an immediate ban on new drilling, which would affect water injection and steam injection.
Yeah, and I'm not talking about putting produced water or even steam injection back into the ground into existing facilities. That's not what we're talking about here.
I understand.
Yeah, we're talking about you need to put new wells in.
I understand.
Right.
But
And the question is how quickly?
New wells, how soon
Okay.
would it shut it down?
There are varying estimates, but if you look at the testimony of the witnesses, it is concluded, and I have the citations here if you like them, but it's anywhere between 20 to 25% per year.
20 to 25%, what, reduction in?
Production decline, yes. And then but what happens is it's not linear, okay? Eventually, because the bombardment is constantly being bombarded with water that's coming into the formation, the steam chest will collapse. And once that happens, as Mr. Tubbs testifies in his declaration, once that happens, you can't reestablish that new steam chest. It's not economic to do it.
So a period between 4 to 5 years.
No. It's not linear. I mean, what we know from, for example, as Mr. Tubbs testified in his declaration, they stopped new steam injection and production wells in the Aera with the thinking that the steam would remain there for some period of time, and that the production values would continue to drift off and go down, but they certainly wouldn't collapse. That's not what happened. In fact, they learned that as soon as they stop the injection, it absolutely plummets to zero.
Whose obligation is it when you face a challenge to show that there's deprivation of all economically viable use?
I think that's my obligation.
And the question is, if it's not immediate and complete or nearly complete, in the Lucas case, he was not deprived of all use of the property, but of a significant amount of use of the property.
Your Honor, if you shut off, if you allow this measure to go into effect, and no, we can't put any new wells in, okay? Chevron is a business like anything else, like any other company. It's a business. They're going to make an economic decision. They're not going to put any more capital in this field. That will stop. And the abandonment liabilities, which will be significant, will accelerate. And I submit to the court that those two factors, along with the fact that we know from the testimony that's been submitted by Mr. Tubbs and others as well, we have these other declarations where the testimony is consistent, that the economic value of the field will dissipate very, very quickly. And certainly, okay, and this is the most important part, certainly much more quickly than it will take for us to go through an exemption process and an as-applied challenge in this court. Okay, that will most definitely take much too much time. And I know that Professor Thompson talked quite a bit about Section 6, and I'm not going to repeat what he said, but I do think that it's important to note, and we cited these cases, particularly in our reply briefs, the City of San Jose versus Operating Engineers case and the Los Angeles County Employees versus County of Los Angeles case are both cases where there were exhaustion provisions in either like a bargaining agreement or an administrative process that was allowed in the Operating Engineers case. And in both cases, the court said, hey, wait a minute, these exhaustion provisions are far, far too time-consuming. They'll never get to sufficient or adequate relief. And under those circumstances, you don't have to exhaust, okay? You can just simply go immediately to the court. And that's where we are today. We're before this court seeking to have Measure Z invalidated based on the fact that it violates our constitutional rights. If you look at Measure Z, just take a look at Measure Z and the ordinance that they want to pass, that they're proposing. The measure itself has no stay provision in it. It just goes, it's effective immediately. So there's no new wells, goes into effect day one. And look at the exemption process that they propose. Now that hasn't been approved yet by the Board of Supervisors, but I suspect it's going to be something close to this. It's still kind of fine-tuning it. First off, you have to go and you have to put all your essential evidence together, which will take some time. And you have to file a claim with an application that has at least 12 categories of information. And that will take a substantial amount of time. Then the county has at least 60 days to determine whether or not what you submitted is complete. And if they say, hey, we don't think this is complete, you gotta start over again, fill in whatever they think is missing, and you start your 60 days over again. Then the county will set the matter for a hearing with a hearing officer. I guess it's gonna be an ALJ or something like that. And that hearing officer has half a year to the completeness of their determination. And interested parties can participate without limit. The hearing officer will hold extensive hearing process, where evidence will be taken and briefing will be permitted. And then the hearing officer has 90 days to submit the recommendation to the Board of Supervisors, who then has another 90 days to set a hearing, just a hearing before the Board of Supervisors to hear your matter. And there's no time limit upon which they have to render a decision. The Board of Supervisors' final decision after staff presentations may occur, but the board may continue the hearing or return the application to the hearing officer. And of course, there's no consequences for the county, or the ALJ, or anyone else involved in this process for failing to abide by any of these deadlines. It'll take years to go through this process. And meanwhile, the Chevron San Ardo operations will collapse, and they will have no value. It's already taken, and this court has been on a rocket docket on this matter. Okay, we put this stuff together pretty fast. It's already taken 1 year just to get to the first phase of this trial. There is a very simple remedy that Professor Thompson outlined that I want to talk about, and it does come from the Hensler case, which he quoted. And it prescribes that the court can simply issue a declaratory judgment, making a determination that Measure Z on its face constitutes an unconstitutional taking. And then, and I would also request, of course, that the court stay implementation of Measure Z until the county makes a determination on its choice. But then the county goes back, they weigh whether or not they want to implement this no new well provision. And if they want to do that, they want to stop all the wells from being drilled, they can do that, but then they got to compensate us for it. Or, alternatively, and in my view probably more likely, what they will do is they will just abide by the court's decision that in fact the measure is unconstitutional and unenforceable, in which case we are done. Let me add one other point, and I think this is really important because it does matter to my client, and it really does matter to the royalty owners that I represent and the school district that I represent, and with respect to the other plaintiffs who are also before this court. And that is that this county has, let me back up, that there is no ultimate recourse at the end of this procedure, this exemption procedure, against the county, should they make a determination that they're not going to void Measure Z. The auditor of the county, this is just based upon the information that they get on the reserves, estimates that the reserves are somewhere between $1 billion and $500 million. And of course, the county's not insured for that. And the county appraiser, again, before the Measure Z went into effect, made the following observation, and I think this is quite telling. These expected losses in taxable revenue, supplemental assessments would hurt the overall economy of the county and render the county helpless to supply many of the county's services it currently provides. But then it goes on and it says,
your reference to these items is relevant to this phase of the case on what issue?
On the issue that this court should make a finding that it's unconstitutional because we can never be compensated. We can never be compensated. They don't have the resources to compensate us. He says that they're going to go into bankruptcy if they have to pay for the economic value. It'll send them into an economic black hole that they will never escape from. If we have no recourse at the end of these proceedings, and I submit that there is a take, if you're going to take the property of these plaintiffs, then you're going to have to pay for it. And if you can't pay for it, then this should end in a facial takings proceeding. And we should not be put to the vagrancies of this administrative process, which will take years and years, and then having to come back to this court for some type of as-applied Penn Central analysis, only to have the county then say, well, we can't pay for it anyway.
Doesn't the county have the option of simply walking away, as Mr. Thompson indicated today, if it's a facial taking?
Absolutely, they do, and that's what I'm asking this court to do. I'm not telling this court that the court should say that the county can't pay for it. If they want to, they can pay for it. And if they don't want to pay for it, they can walk away.
Okay, so then we come back to why is the county's ability to pay is potentially
Well, I think it's.
this explosion relevant at this stage of the proceeding?
I think it lends some color to the notion that we know where the county is going to go. Okay, if you make that ruling, the county's not going to pay for this. They can't afford to. And I think that's something that's relevant that the court should consider. Yeah, the court will make it. I'm sorry, Your Honor?
I'm not entirely convinced that's the case.
That they would not pay for it?
What the county's decision.
Yeah. And that's their choice. If they want to spend their dollars shutting oil down in Monterey County, that's a political decision they'll make.
Decide to file bankruptcy, you can pay for it at pennies on the dollar.
It might, and look, I mean, and there'll be political consequences for that, no doubt. But that's our system of government. Okay, but right now, the only question before this court is, and I think it's incumbent upon the court to look at what's happened with this initiative and what it's going to do immediately to my clients and the other plaintiffs. And I submit to this court that it is going to have a devastating financial impact on the oil operations in the county. And it's going to be an immediate problem that the county has no recourse, that we have no recourse against the county if we have to go through this process over. And I submit that I join in Professor Thompson's comments concerning Section 6 of the measure, to the extent we believe that it should be voided as unconstitutional. And unless the court has any other questions,
No. I asked a question. Thank you.
thank you very much, Your Honor.
Thanks, Mr. Thompson. Mr. Bassett?
Morning, Your Honor. Rearrange here, Your Honor. morning, again, Your Honor. Andrew Bassick on behalf of Aera Energy, and I've also been asked, in the interest of conserving time, just present some comments on behalf of Eagle and Trio as well. So I'm cleaning up for the producer side. I believe that Mr. Renwick will have a couple of comments on behalf of the royalty and objector on that. Where I would like to start is with the question you put to Mr. Dinser, and I want to make sure that we on the producer side have answered it adequately for you. You have two, and I think my presentation is designed to be focused on both of them. The first question is, when is the economically viable use taken? And the fact of the matter is that the moment Measure Z becomes effective, the very valuable asset of the San Ardo and Lynch Canyon fields for the producers, for everyone across the board, is converted from an asset to a liability because of the prohibition on new wells, because of the prohibitions on the handling of water. It is immediately converted from an asset to a liability. I'm not going to repeat Mr. Thompson's exposition on what the law is on this area. I just want to touch on some of the evidence that bears upon the timing, and then we'll talk about the 5-year amortization provision. Mr. Kemp of Baker and O'Brien submitted a declaration that is directly responsive to your question. What his analysis, his independent expert analysis concludes is, due to the immediate decline in production rates resulting from the prohibition to drill new wells, it's unlikely that sufficient income would be produced from existing wells at current market prices for oil and natural gas to recover capital expenditures or field abandonment costs during the phase-out period or within a reasonable period of time. In total, these field abandonment costs can be expected to amount to hundreds of millions of dollars, which is unlikely to be recovered if oil and gas prices remain near the present levels. Now that's in the context of no new wells and the 5-year amortization period. What the Baker and O'Brien report indicates is that the 5-year amortization, the producers won't make it 5 years, even if that period is legal and is applied here. Simply being unable to install new wells will, and knowing that you can't get more than 5 and maybe 15 years out of it, but it doesn't matter if you can't install new wells. What's going to happen, and Mr. Dinser referenced this, but I just want to make sure we focus on it, that the end of field life costs, the closing out of the thousands of wells that are out there, the cleanup and removal of the equipment, all of those costs, which are now present value because it's anticipated that they're out another 90 to 100 years, suddenly comes home to roost in the next 5 to 15 years at most. And so what that means is that's where I can say with great confidence that the moment Measure Z comes into effect, the oil fields, the oil operations, the ownership of these properties becomes a liability instead of an asset, because of all the work that has to be done and how expensive it is and how that gets moved up in time. The taking is immediate and complete. Let's go to the next slide. Mary Jane Wilson, another independent expert, who submitted a declaration. Measure Z provides for an immediate ban on drilling a 5-year, quote, phase-out, quote, period, end quote, period, for produced water disposals and means to avoid it, quote, taking, end quote, of mineral assets. However, the result of such a shortened time horizon is that the planned development opportunities to enhance capture zones and better fluid dynamics from improved reserve recovery are lost immediately. Oil producers will make net present worth decisions to let all contracts matriculate pay for cancellations, reassign or terminate non-essential personnel, and cease producing one of California's largest oil basins. Once the abandonment is complete, there will be no economically feasible way to recover the lost mineral reserve. Immediate and complete loss. As soon as you can't drill new wells, the steam chest will start to deteriorate. The oil companies know that, and that it's just not going to make economic sense to continue to invest in the property.
Is it your position that even though some continued production could take place without new wells, but after that period, and basically the amount of production that could be realized during that period is more than offset by the costs of closing the field down?
It's not my position, it's the independent experts' opinions that that is a fact, having analyzed the
I
situation.
assume you're
But yes,
endorsing that.
yes, absolutely. And it is the rushing forward in time of those costs that flip this asset, these assets, to become liabilities and significant liabilities immediately. There is in the Baker and O'Brien report attached to the Kemp Declaration a step-by-step discussion of how either the no wells prohibition or the prohibitions on handling of produced wastewater will result in the immediate termination of the field. I put up a graph right now that shows what will happen to the production rates. The red line indicates what would happen if the producers were to uneconomically continue to invest in the same ways that they have over time to maximize production from the field, regardless of it being an uneconomic decision to do so. So you get a little bit of bump of that. The blue line, according to Baker and O'Brien, is what the runoff would look like in an economic approach by the producers. A 17% per year decline, where you would reach zero before you even get to the first 5 years. And again, I'm not going to read you the whole report, but the rationale and all the supporting information for this chart is in the report along with this graph. And I want to make clear that one of the things we worked very hard with Baker and O'Brien to do is to make sure that the information presented in that report is not specific to any one producer. It's not specific to any one party in this litigation. And it's also been produced entirely from information available in the public domain. And there's a list of sources that Baker and O'Brien accessed that's attached as an exhibit to the report that you can review, that everybody can review, from which they derived this information. It's been corroborated by what you'll see in Ronald Sasaki, Aera's field manager's declaration, and it's been corroborated by what you'll see from Dallas Tubbs' declaration on behalf of Chevron. But the work to put this together independently was done by Baker with public information. I don't want to belabor the already in-depth discussions we've had about the need to dispose of produced water by injection and what will happen to that. If we could skip ahead to slide 11. Well, what I have is 11. No, the next one. So we've talked a bunch about this, that for every barrel of oil recovered, 14 to 19 barrels of water are produced. That water's got to go somewhere, Connor. I mean, it's got to go somewhere. Let's go to the next slide. This is another very informative chart in the Kemp Declaration. While we all shouldn't squint too hard at it, the bars on the graph represent the total fluids produced. The little dark tips at the top, the black, that's the oil, and the rest of it is the produced water. Just to give you a relative sense over time. The dotted line tells you what the percentage of water to the entire is over time. Next slide. So, on the whole, what happens to the produced water after the oil is removed for it? 44% of it is converted into steam, leaving 56% of the rest. 43% is reinjected, 10% gets processed into purified wastewater and is disposed of into the wetlands. 3% remains as a brine stream. So, in terms of demonstrating why other methods are not economic. In fact, first let's touch base quickly on the next slide. So if we can't re-inject, we the producers, it's game, set, and match. Ron Sasaki from Aera, there is no method for legally and economically disposing of a large volume of produced water other than the injection of that produced water into the ground under oil-bearing formations. Dallas Tubbs from Chevron, in his declaration, agrees. As a result of the injection and impoundment prohibition, the impending shutdown of the field precludes the necessary capital investment needed to operate an oil field of this size. Independent expert Baker and O'Brien also concurs. The wastewater injection or impoundment prohibition is expected to bring an end to the existing San Ardo oil and gas operations. With the expiration of the 5-year phase-out period, Measure Z will directly prohibit impoundment and reinjection of 2/3 of the water produced every day in the San Ardo field. So, the Baker-O'Brien report notes that as of 2016, the produced water, and let's go back to the pie chart if you would please. The amount of water produced, the total of this pie chart, is 15,000 acre feet in a year. If you multiply that by the number of gallons in an acre foot, which is 325,851, that's 4,887,765,000 gallons per year of water. And if we continue to do a little bit more math to see what this means, if we have to deal with the water by some other method, how much, so you take 56% of that number, excluding, well, it's actually, we're just talking now about the brine and produced water, excluding the RO, and divided that by 365 days, 6.1 million gallons per day that have to be dealt with. Now, a standard tank truck holds just over 5,000 gallons. That's over 1,200 additional tanker truck loads of fluids per day that need to be dragged out of the field that are currently being injected. That's more than 2,400 round trips, for to wherever it's being taken. Mr. Burzloff suggested Coalinga, which is 134 miles away. That's
Where did he make the suggestion in his declaration, or in his
in
declaration?
his deposition. Okay, fair enough, Your Honor. Let's just say, but I'm just saying, if that were the case, and even if I suggested it hypothetically, it's still 2,400 trucks. That's 327,000 miles of truck traffic per day to haul the water. Just to conceptualize it. All right, let's go to a couple slides ahead. I'll flip away to this next one. Next one. Mr. Tubbs talking about it not being economic under Measure Z to operate the reverse osmosis facility. Next slide. So defendants suggest that we the producers just RO all of the water as one solution. Well, okay. Ms. Fletcher the other day said the brine produced, assuming we were to RO all of the water, not that is economic in any way, could be trucked elsewhere. And a truck could be used to take the brine outside of the county to a different jurisdiction. I reran the numbers for the brine alone, using the entirety of the water, that 1,500 acre feet, the 15,000 acre feet. You're still going to end up with 744 additional truckloads of brine per day. That's 100,000 miles of truck traffic every day to drag that out of the county. That's it. My point here, Your Honor, is that these workaround solutions aren't really solutions, and that the taking is complete upon the enactment, the effectiveness of Measure Z, and that will flip these assets, this field, from an asset into a very significant liability. I want to flip ahead to, let's go to the next slide. Next slide. Next one after that. This is an excerpt from the Baker and O'Brien report, which reiterates what the point I was making earlier. The costs are accelerated. The producers will look to conserve capital. The steam chest will collapse, and the taking of the value is complete from day one. All right. Now, you also, second question, you raised the question of amortization. It's 5 to 15 year amortization period. Let's go to the next slide. Here is a portion of LE 122. All non-conforming land uses under this policy shall be discontinued within 5 years of the effective date. Any such extension may be that you can get an extension not to exceed 10 years to go forward from there. Your Honor, amortization doesn't work. You can't do it. It's not our position is that amortization It cannot be legal for an asset like an oil field. And there are 3 reasons for that. First of all, unlike most businesses where you have a capital expense up front to set up your restaurant, to put in your facilities, whatever they are, and then you have ongoing operating costs as you operate the business. A very typical business model. Oil fields are different. There are capital investments that need to be made constantly throughout the life of the oil production. You cannot amortize that in the same way that you can a business that's simply dealing with operating expenses. And I want to be clear that I'm not going to argue about whether the length of this period is reasonable. It's not, but that's for, if we ever get to an as-applied challenge, we'll address that then. For right now, we're saying as a matter of law, you can't amortize an oil field, period, end of story. And why that is, you'll remember the quote from the Hansen brothers case. If an oil field isn't expanded, it can't continue. Mineral extraction is ongoing, requires major dollars to be invested every day. You're never going to catch up by amortizing, to the extent you're having that represent the value somehow. Second point, oil fields, unlike some of the other businesses that have been subjected to amortization over the years, are unique because you can't move them. The oil, the mineral resource, you have to take it where you find it. Again, going back to the oft-cited Beverly oil case, oil production is a business which must operate, if at all, where the resources are found. And they've been found here, and the producers and the mineral owners have been producing from them for a long time now. Let's take a look at some of the cases that are out there that are cited by the interveners and the defendants, saying that amortization is proper. Los Angeles versus Gage, a very noisy plumbing business that was rezoned despite having been certificated and approved. The amortization was done with the idea that it could be relocated. Livingston Rock and Gravel Company. Now, this is not a gravel mine. This is a cement mixing plant. Same thing. This is a business that could be moved. The Elysium Institute case, a nudist camp case, not that expensive to relocate compared to the other ones, but relocatable nevertheless. Same thing with Gates, with the auto wrecking yard, which the owner of that property did themselves no favors with how they dealt with the court, but ended up being amortized and moved. Same thing with the billboard and adult bookstore cases, of which there are many. None of those assets is analogous to an oil field. The unique, non-movable nature of it. You can't go to the middle of somewhere where there's no oil and continue to produce it, no matter how much amortization you get. And that brings me to the third and final reason why amortization can't work. Many of these other businesses are operated on leased facilities. In some ways, I suppose people could say that an oil operation is a leased facility. And amortizable businesses don't require a ton of ongoing capital, are relocatable. But the third, this is a summary. The third point, is the one that I want to make, is the third bullet on the right side. There's a duality to the nature of mineral extraction businesses, because the operational aspects, the pumps, the contracts with the truck workers and the people who are operating the equipment and transporting the what's moved are one piece of it. But the right to the minerals is a real estate interest, and you can't amortize that. That has to be bought. That has to be purchased. You can't look at that the same way and say, you've got an operating business selling oil, so we're just going to amortize you away and send you off. You have to address the fact that there's a profitable real estate interest there as well. That's not subject to amortization. I've not seen where people have had an amortized. I haven't found a case where a piece of real estate was amortized as opposed to some use of it. So for those reasons, amortization is not applicable to an oil field at all, and that 5-year period should not be enforceable. And I hope that I've answered your question on the immediacy of the field turning from an asset to a liability, but if you have other questions, happy to address them. I think we're ready for our new break.
Thank you. Just for scheduling purposes, someone else going to argue on behalf of plaintiff petitioners?
I think Mr. Reddick might want to have 35 seconds or so. 2 minutes, 120 seconds.
Oh, that's too late.
Okay. Pardon me, Your Honor. Seem to have come down to the cold up here. I just wanted to show for the record that it's Edward S. Renwick representing the NARO and 80-some odd mineral and royalty owners from South County. And I just wanted the record to show that the number of my clients from South County have mineral interests that have been severed from the surface. And hence, they are directly impacted by facial taking. Because they have, well, once a mineral interest is severed from the surface, there's no other use that you can put that severed mineral interest to other than producing oil. And they are, so I want to enthusiastically join in the comments of my 3 colleagues who preceded me this morning. The only other thing I want to do is answer a question on behalf of my clients. And you asked how long or when the spatial taking would occur. And as far as my clients are concerned, I'm talking about my mineral owner clients from South County. It happened about a year ago when Measure Z was enacted, because at that moment, there's a market for oil and gas interests, for mineral owners' interests. And the moment that happened, the Measure Z was enacted, they think that the value of their mineral interests went to zero. If they tried to put their mineral interests out on the market today, they wouldn't be able to move them.
Is this in the record, Mr.
It is not, and it is something that we will prove if we ever get to the second phase. But this is it's a glimpse of coming attractions, Your Honor, and an effort to answer your question from our standpoint.
Do any of your South County clients have mineral interests where no production has been undertaken yet?
Yes. How many, I can't tell you. And a lot of them have the bulk of my clients' mineral interests are subject to operations, and particularly in the San Ardo field and Lynch Canyon. We're kind of across the board here.
Thank you. Folks, as much as I'd like to start sooner than 1:30, I'm the only judge here today in the civil division, so there are undoubtedly many fires waiting. let's talk about injury objections. When I would frankly pay attention, because once I heard everybody's theories about the relevance of this evidence, then I'd be in a better position to rule on those and strike items that I found were not relevant and perfectly capable and that for many years simply excluded consideration of such matters from the court's decision. I realize this type of proceeding is unique in many ways. But the case law certainly indicates that certain evidence is not only relevant but necessary in order to establish certain types of claims. So I certainly meant no offense was coming.
And I didn't need to, he said I had 4 apologies.
Okay, so we'll see everybody